let's go ahead and start with confidential information in narcotics case. If we can go to that first slide. So this is something we deal with frequently in our narcotics cases. And to effectively prosecute cases that have confidential information, you need to consider a number of things. First, what type of confidential information are we dealing with? A concerned citizen who wants to stay anonymous, a paid informant working for the police, a cooperating defendant working off an existing case, or are we dealing with the need to protect ongoing criminal investigations or police tactics? Next, how are you going to protect that information? This includes redacting investigative reports, not just the personal identifying information of the witnesses, but also any information that would tend to reveal ongoing criminal investigations that you want to protect, or that would jeopardize or compromise the safety of any informants that are working in your case. Are you going to need protective orders in your cases? Are you going to disclose right away? Are you going to delay disclosure? Are you going to deny disclosure altogether of this confidential information? Are there privileges that you can assert and have your witnesses assert during hearings if they're asked questions that would tend to reveal confidential information? And what are you prepared to do as an office, as a prosecutor, if you get an adverse ruling from the court ordering you to disclose something that you absolutely do not want to disclose? Next slide, please. Deconfliction. Deconfliction is something that routinely happens at the investigative stages in our narcotics cases, more so with the long-term investigations. And that's done by the law enforcement agencies. But of course, not every narcotics investigation is a long-term investigation. And deconfliction happens not only by the law enforcement agencies, but as prosecutors, we need to deconflict as well. That means looking, are there other jurisdictions, federal or state, that are prosecuting your same defendant? And what effect, if any, will your charging of a case have on those investigations and those prosecutions, or theirs on yours? Is there a wiretap investigation that is ongoing? In narcotics, we are probably the bread and butter of all wiretaps out there. The vast majority are going to involve narcotics investigations. Is there one currently in existence targeting your defendant? Or even if he's not targeted, was he picked up as a result during the course of the wire? Was communications intercepted? And there are complex, strict discovery obligations that you have when you're dealing with wiretap evidence that you're going to need to be aware of in case you have a defendant that's picked up in a wire, federal or state. Next slide, please. Another consideration, special consideration for narcotics cases, is the identification of the controlled substance. In your jurisdiction, is the officer's opinion enough that they, based on their training and experience, they believe the substance to be whatever it is they claim it is? Do you have requirements that there be a presumptive test in addition to, or at a minimum, with the officer's opinion at a preliminary hearing or a probable cause hearing in order to bind over and go to the next stages to trial? And also for trial, do you have labs that are going to give you a confirmatory test in time for that trial? Next slide, please.
1 minute.
Common defenses in narcotics cases is something that you need to consider, or you should consider. These are not my pants is still a common defense. Even more common is something like the blind mule defense that we see quite frequently in San Diego. That's someone that's crossing the border from Mexico into our jurisdiction, and they claim, I had no idea that that stuff was in my car. Someone must have put it in there without my knowledge. How do you overcome that defense or those defenses? What does the law in your jurisdiction require in terms of knowledge of the nature of the controlled substance? Do they have to know it's fentanyl? Do they have to know it's meth? Or is it enough that they know that it's just a controlled substance? You need to be prepared for those type of questions in your cases. If it's a sales case, were those drugs possessed for purposes of sale, and how do you prove it? Or is it just personal use? And finally, another thing that we're seeing with increasing frequency are claims of duress. And that's here, it's like the cartel said, I better cross this load or they're going to kill my family. How do you overcome those type of situations? So lots of questions, lots of considerations. And when I have more than 2 minutes, maybe I'll give you some answers. Thanks.